Hamilton famously called the courts the least dangerous branch, yet the ability to strike down laws seems like an awesome power, especially in the Supreme Court, whose decisions are final and unreviewable by any court but itself. So what are the limitations on judicial power? First, let's ask how limited we actually want the courts to be. Article 3 is pretty careful to protect judicial independence. It does so by saying the judges shall hold their office during good behavior, i.e., for life, unless they're impeached and removed, which has never happened to a Supreme Court justice, and shall receive for their services compensation which shall not be diminished, so you can't cut their pay. Article 3 does these things because judicial independence within reasonable limits is a good thing. Think about the court's unique role in protecting minority rights. For example, desegregating schools, which is something that neither of the elected branches were brave enough to do in 1954. The fact that the court does not have to answer to voters makes it the only realistic option for protecting the rights of very unpopular groups, like people who would burn the flag or religious groups that sacrifice animals. In addition, judicial independence should mean that the justices don't have to bow to pressure from the other branches. Think about how 3 of the men President Nixon put on the court stood up to him in U.S. v. Nixon and voted to force the president to turn over the Watergate tapes. So, always keeping in mind that a reasonably independent judiciary is the goal, we'll now look at what the checks on the court are. And the way this is going to be organized is, in this lecture, we'll look at the checks that come from outside the court, from the other branches or from the people. I'm going to further divide this section into the checks that are thought of as more routine or legitimate, and those which are extreme, exceptional, or dangerous. In the next lecture, we'll look at some of the checks that come from within the court itself. First, it's incontestable that a constitutional amendment can overturn a Supreme Court case. This has happened at least 3 times, debatably more, but these will be the ones we'll focus on. The 11th Amendment, which says that a citizen can't sue a different state except as authorized by that state's laws, overturns Chisholm v. Georgia, which said that you could sue a different state. The 13th and 14th Amendments both overturn parts of Dred Scott v. Sanford, which infamously protected the rights of slaveholders and said that African Americans could never be citizens. The 13th Amendment bans slavery, the 14th grants citizenship to all who were born here. And we've already looked at how the 16th Amendment, which permits a federal income tax, overturns Pollock v. Farmers Loan and Trust, which forbid it. Of course, amendments don't come around every day, and so a far more routine check is simply passing laws in response to court decisions. This can be done anytime it's believed that the court is underprotecting or overprotecting rights. For an example of the first situation, let's look at Employment Division v. Smith. This case dealt with the religious rights of Native Americans. The state of Oregon banned the use of peyote, a hallucinogenic drug derived from a type of cactus. Some Native Americans who used the drug in their spiritual rituals protested the ban as violating their religious freedoms. What they were asking for was a religious exemption, special permission to get out of following an otherwise enforced law. The Supreme Court in Smith tells them, no, your religious beliefs don't mean you can go breaking our drug laws. But the really interesting thing is what happened next. Congress, in perhaps its only moment of decency towards Native Americans in our whole history, is outraged and passes the Religious Freedom Restoration Act, or RFRA, pronounced RFRA, which does grant such groups a religious exemption. Can they do that? Sure. The First Amendment, as interpreted by the Supreme Court, provides a baseline of rights, but Congress is free to go above and beyond and protect rights further, at least at the federal level. So all of this is fine and above board, but notice that the practical effect of passing this law is to overturn the court in Smith. Here's another example of legislation checking the court, this time narrowing the scope of a right. Roe v. Wade established the right to a first trimester abortion nationwide, but as I'm sure you know, it was, shall we say, controversial. In response, conservative states passed more abortion restrictions than you can count. parental consent laws for minors, spousal consent laws for wives, laws requiring women to get an ultrasound or enter counseling before undergoing the procedure, and most of all, very tough, picky restrictions on abortion clinics, which are regulated up to the same extent as hospitals in some cases, which are, it's kind of acknowledged on all sides, designed to be so expensive to comply with it forces abortion clinics to close. Now, many of these restrictions have themselves been struck down, but the states keep responding. It's resulted in what some commentators have called a conversation between the state legislatures and the courts. The states keep on testing the limits and seeing how far they can take it. And a determined state can take it pretty far. As we see, several of these conservative states like Kentucky, Missouri, Mississippi have only one abortion clinic each. And I think what that shows is that a determined state really can outmaneuver the Supreme Court if it's dedicated enough.
A third check is far more slow-changing and long-term. It's the confirmation process for getting new justices on the court. Now, when I say this is a long-term project, I mean it. Justices, of course, serve for life terms, so they are normally the last branch to react to political trends. Roe v. Wade was decided in 1973. It was overturned in Dobbs v. Jackson Women's Health 49 years later. For every day of those 49 years, the pro-life movement worked and sweated to overturn that decision. From the standpoint of sheer democratic participation, it was an incredible movement. Millions of people organizing, knocking doors, making phone calls, and election after election. Roe was a 7-2 decision. Somehow, the pro-life movement had to flip 3 of these votes. And the best way was to fight every time a new seat on the court came open. Part of the struggle was to increase the salience of judicial nominations. Republican Party politicians started having to promise to prioritize appointing anti-Roe judges in order to win support. As a candidate, Donald Trump published a list of names he would consider for appointing people to the High Court. Publishing this list helped build trust among the pro-life base. In elite conservative legal circles, a group called the Federalist Society was born. This group had a mission to build a pipeline of talent into a network of judges who would take conservative positions on all the big questions. From the minute that new law students arrive at college, the Federalist Society pushes right-leaning students to join. It always has plentiful free food, supplied by a well-organized cadre of donors, always has the most professional, well-organized events and parties, and always has the best inside path to career opportunities like clerkships and high-paying corporate jobs. It gives law students and young professionals booklets on every topic, teaching them the official Federalist Society stance on which cases are good and which should be overturned. Joining the Federalist Society, or FedSoc for short, is a great career move for any young Republican lawyer. The benefit as far as FedSoc is concerned is that the Republican Party thus has a plentiful stream of talent whose political views are well known and who have been trained for the bench. Every time a seat opens in the federal courts, FedSoc is ready to recommend a promising young member who can be a faithful adherent to conservative legal ideas. I go into all this detail to point out that changing the composition of the courts is far from easy. It's a multi-generational project, but organized groups are out there trying to do it. The conservative groups who invested decades in this project did manage in the end to achieve their greatest dream, overturning Roe. Thus, changing the composition of the courts is a long, slow check on the judiciary.
Alright, right here is where we move from the traditional accepted checks to the ones that seem extraordinary or dangerous, starting with the exceptions clause. Article 3, Section 2 has a little noticed piece of text which provides that in all other cases the Supreme Court shall have appellate jurisdiction with such exceptions and under such regulations as the Congress shall make. Now, this has very rarely been done, so there's not a lot of definition. We don't know how the contours of this clause play out. But if you think that that might allow Congress to exempt certain areas of the law from judicial oversight, you might be right. One of the very few cases on this topic is ex parte McCardle. McCardle was a Southern Confederate sympathizer who was jailed under the Reconstruction Act, which provided for the military occupation of the South immediately after the Civil War. McCardle sued, and as his case was pending in the Supreme Court, Congress, deeply worried about whether the Reconstruction Act was constitutional, passed this law basically saying, the Supreme Court shall have no power to hear cases arising under the Reconstruction Act. So the court says, okay, Congress, you win, we're not going to hear this case after all. Too bad, McCardle. Does this seem dangerous to you? It seems dangerous to a lot of people, which is probably why it hasn't been repeated. But understand the possibility is out there, and every few years you get the odd congressperson who suggests we do something like ban the Supreme Court from hearing a same-sex marriage case. Next, we've already talked about how FDR's court packing scheme was successful in getting the court to change its vote. Turns out that's just the tip of the iceberg, because there are all sorts of technically legal but highly shady ways to mess with the court if you really have a mind to do so. You could take away the court's law clerks. You could stop funding the use of their building. They don't have to have a building. You could eliminate all the circuit courts and make them hear all the appeals themselves. I mean, there are endless ways to run the court into the ground. It's just that all of them are crazy. None of these except court packing has ever even been proposed. But, you know, they have neither the purse nor the sword, and all that. Which takes us to our final check, simply defying them. We already know that President Lincoln did this over the issue of habeas corpus in the Civil War. Let's look at another example, the immediate aftermath of Brown versus Board. We have not done a good enough job teaching Americans how openly defiant the South was towards this decision. You've perhaps heard about how it was necessary to send in the National Guard to escort the Little Rock Nine to school. Well, you probably don't know the half of it. All across the South, a network of white activists participated in the massive resistance movement. Massive resistance was what they themselves called it. Governor Wallace of Alabama stood in a schoolhouse door blocking African American students from entering. Whole districts closed their schools rather than integrate them. Imagine preferring that your student stay home and not learn how to read rather than go to school with a black kid. Massive resistance was so effective that 10 years after Brown, only 1 in 85 Southern black children actually attended integrated schools. 10 years later. If a whole region puts its mind to it, and here's the crucial thing, if voters are rewarding public officials for defying the court, Governor Wallace became incredibly popular. His antics set up a presidential run in which he won 5 southern states. If voters are rewarding politicians for defying the court, they will defy the court.